Welcome to Clackamas County, October 23rd, 2023. This is the Planning Commission. Tonight, the public hearing is now open for, excuse me, let me back up. We need a call to order, please.
Commissioner Stevens.
Here.
Commissioner Lopes.
Here.
Commissioner Murphy.
Present.
Commissioner Middaugh.
Here.
Commissioner Peterson.
Present.
Commissioner Wilson.
Present.
And Commissioners Moss and Pack are absent.
Commissioner Moss will show up later, I think. Nope, absent. Okay. Okay, Darcy, do we have any public comments?
So this is an opportunity. If there's, I do see there are two attendees. They may very well be here for the application that we're hearing tonight. But if either of the folks in the audience wanted to make a comment to the Planning Commission about something unrelated to tonight's hearing, but just a general public comment related to some business before the Planning Commission, please indicate by using your raise hand feature. I don't see any, Murph.
Okay. Moving on. The public hearing is now open for the consideration of file numbers Z0315-23-CP, Z0316-23-R, which are applications by Everett Griffin for the comprehensive plan map amendment and corresponding Willamette River Greenway application for a dock. Assisting us in the hearing today are several members of the county staff, Principal Planner Martha Fritzy, Planning Director Jennifer Hughes, and Administrative Specialist Darcy Reinhardt. The public hearing is being conducted virtually using Zoom platform. Panelists for today's hearing, which include members of the Planning Commission and county staff, both have audio and video capability. The application will be added as a panelist. The applicant will be added as a panelist during the presentation. If the panelist is participating with audio but not video, member of the audience will not see the panelist's name on the screen, but will be able to hear when they speak. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post this recording on the county website as soon as possible. The Planning Commission is charged with making a recommendation on the application of the Board of County Commissioners. The record from this hearing will be forwarded to the board, which will make the final decision on this matter. The board will conduct another hearing on this application on November 29th, 2023 at 10 a.m. The hearing will be de novo, meaning that the hearing will start anew and additional testimony may be offered. Tonight's hearing will not go beyond 10 p.m. unless a majority of the planning commissioners in attendance vote to continue past that time. If not concluded, it will be continued to a date and time certain. The hearing may be continued for other reasons as well. If announcement of an additional hearing date and time is made tonight, it'll be the only given notice of that additional hearing. The public hearing will be conducted as follows. Planning Commission Planning and Zoning Division staff report, enter into the record of any additional correspondence received, technical information from other government agencies, testimony by the applicant or representative, maximum length 60 minutes. Testimony by representatives of recognized community planning organizations and hamlets, maximum length 10 minutes per CPO or hamlet. Testimony by proponents of this application, maximum length 3 minutes per speaker or more if determined by the chair. Testimony by opponents of this application, maximum length 3 minutes per speaker or more if determined by the chair. Testimony by persons who are neutral on the application, maximum length 3 minutes per speaker or more if determined by the chair. Applicant's rebuttal, which is limited to arguments addressing evidence already in the record, maximum length 30 minutes. Planning and Zoning Division staff's rebuttal, which is limited to addressing evidence already in the record. Closing of the public hearing, Planning Commission discussion and action. There is a designated time during the hearing when it will be open for testimony. The chair will make it clear when this is. If you want to provide testimony, you will utilize your raised hand feature in Zoom. Attendees on PC or iPad, you have a raised hand button on the Zoom bar or bottom, depending on the device. Attendees by telephone, use *9 to activate the raise hand feature. When the moderator switches you over to provide testimony, your screen will look different. For a moment, primarily, you will see participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. For the record, please begin by stating your name, where you're from, and whom you're representing. If you would like a copy of the final Board of County Commissioners decision on this matter, please provide your mailing address. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. Now is the time set for a public hearing related to the previous identified comprehensive plan amendment and Willamette Greenway applications. This is a quasi-judicial land use hearing, which means two important things for those participating in the hearing. First of all, the criteria of that Planning Commission can be used in reaching a recommendation as listed in the notice given for the public hearing and will be identified when the oral staff report is presented. All testimony, arguments, and evidence must be directed toward the criteria and other criteria in the comprehensive plan, zoning and development ordinance, or other land use regulations that person testifying believes to apply to this decision. Accordingly, anyone testifying is asked to please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford decision maker and the party of opportunity to respond to this issue may preclude appeal to the Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues related to the proposed conditions approved with sufficient specificity, I know I murdered that one, to allow the county to respond to the issue precludes an action for damage in the circuit court. Once final, the county's decision will be appealed to the, once final, the county's decision may be appealed to the Oregon Land Use Board of Appeals. At this time, I'll ask members of the Planning Commission to disclose any ex parte contact, bias, or conflicts of interest. Please indicate the nature of the extent of the ex parte contact, bias, or conflict of interest, and indicate whether you intend to participate or abstain from this hearing. Anyone?
No.
If anyone wishes to challenge the impartiality of a commissioner, please clearly indicate your intention to do so in any written or oral testimony you provide. The Planning Zoning Division staff will now present the staff report. Martha.
Thank you. I'm going to share my screen. I've put together a hopefully not too long PowerPoint presentation. Bear with me just a moment. Okay. Can you see that?
Yes.
Is it in?
Yeah.
There we go. Now you can't see the slides on the side, right?
Right.
Excellent. So, hello, I'm Martha Fritzy with the county's Planning and Zoning Division. I am going to hopefully briefly walk you through the highlights of the staff report that you received in your packet last week. So as Chair Murphy indicated, we are here to discuss two different land use applications, Z0315-23CP, which is a proposed comprehensive plan map amendment NZ-03163-R, which is an application for a private non-commercial dock on the Willamette River. More specifically, these two pieces include a proposed amendment, a comprehensive plan map amendment to change the Willamette River Greenway designation from limited use to multiple use for a portion of the river that abuts the subject property. This change specifically would allow for the construction of a new private non-commercial dock. The second piece is the application for that dock, and the proposal includes a 700 square foot dock that measures 35 feet by 20 feet. That's the dock portion, does not include the ramp or the gangway portion. That is how we measure docks in our zoning code. So before I get started, and I don't expect you're going to be able to read all the words on this, and that's okay, I just wanted to provide just a little bit of background of what is this Willamette River Greenway. This is not something we have come and talked to the Planning Commission about very often, and I have never talked about it before. I had to do a lot of research, to be honest, to figure out what the heck I was talking about. And so very generally, the Willamette River Greenway is a corridor that includes water and the surrounding land along the Willamette River. It's established through statewide planning goal 15, and cities and counties were required through goal 15 to implement this greenway by adopting the greenway section into their comprehensive plans, creating a greenway boundary and establishing standards for new development, new uses, intensifications of uses within these boundary areas. It was based on my read of the history of the greenway. It was largely intended to preserve areas along the river for public use, but it really is also intended to maintain visual and physical access to the river, and also preserve the habitat and direct development away from the river. It's important to note, though, that directing development away from the river doesn't mean development is prohibited in these areas. But it was intended, as far as I can tell, to do all of those things. Clackamas County adopted this into Chapter 3 of our comprehensive plan. This is the map. It is a very old map. I found the original, well, it wasn't even the original, from about 1980. And this map has not changed notably since 1980. And it identifies areas, it identifies the greenway boundary, and it identifies areas of various land classifications related to urban and rural uses. But what is important for us today is that it identifies two different water classifications, limited use and multiple use. In limited use areas, it's very clear in both our comprehensive plan and our zoning code that new docks and moorages are not allowed. In the multiple use areas, they are allowed. There's two limited use areas. Actually, there's three limited use areas actually, there's only two. I apologize. Along the Willamette River, and one of them starts around the urban growth boundary just south of Oregon City and goes down to here, roughly the area of Balancing Rock, if anyone knows where that is. That's before you get to Canby, and down around Peach Cove. The second area starts at the Canby Ferry and goes west to sort of the western boundary of Molalla State Park. That's the area that we're going to be talking about today. So the subject property is located on the south bank of the Willamette River in this limited use area that starts here at the Canby Ferry and goes west to the edge of the Molalla River State Park. The site itself is about 1/2 acre in size, approximately 1/2 mile west of the Canby Ferry, and it is located within this limited use area. So currently, even though there is a house on the property right now, they're not allowed to build a dock on the Willamette River because of this, because of its location here in the limited use area. This aerial, I think, gives a better sense for what is going on around the subject property. So this is the property here. Like I said, it's about 1/2 acre. This is where the Canby Ferry crosses. Malala River State Park includes all of these parcels down here and goes farther to the southwest. The subject is located on a road that is developed with rural residences, about ½ acre to an acre lot sizes. There's 10 lots there. 9 of these have homes. Of those 9 homes, 5 already have docks. And as far as I can tell, based on research that was done by some previous planners, these docks were existing before the Willamette River Greenway was established in our comprehensive plan, and this was put into a limited use area. It's interesting to note also the residential areas on smaller lots. These are 1.5 to 3 acre lots over here. Every single one of these also has a dock. These are all located in the limited use area. So this area does have some rural residential development, and it definitely has some private non-commercial docks that already exist. But there's also these larger stretches of farmland and natural areas and park areas as well. Despite being developed with rural residential uses, this area is zoned EFU, exclusive farm use. All around the subject property, across the river to the east, this darker green down here is timber zone. That's the Malala River State Park, but pretty much everything else around here is zoned exclusive farm use, including the subject site. So I would not expect a whole lot of additional development in this area. These houses that exist along here, again, were pre-existing both the Willamette River Greenway designation and the EFU zoning. So I wanted to give you a little bit of context before we start talking about the application itself. And so these applications, notice was sent out about the applications and the public hearings that are set. Notice was sent in September. We've only received 2 comments. One was in your packet, Exhibit 3. It was a comment from a neighbor in support of this application. I think it's interesting to note that this neighbor is a farmer who has over 240 acres of farmland between the subject and Canby, so sort of southeast of the subject property, and is in support of this application. The other comment that we received actually came in over this past weekend, was not included in your packet. I think Darcy has forwarded it to you. You probably got it right before the meeting. I apologize. It's a comment from the Division of State Lands in response to the notification that we gave them. It just includes a few comments in there, and to summarize, it acknowledges that additional permits are required for the dock, which the applicant, I believe, knows, and that's pretty standard for a dock on the Willamette River. The local community planning organization is the Aurora Butteville Barlow CPO. No comments have been received from them. So, as usual, when you're looking at a comprehensive plan amendment and any other applications, there are a lot of criteria that need to be looked at. The staff report that was included in your packet includes an analysis of all the relevant criteria that staff found relevant to the proposals. They are listed, most of them are listed here, including statewide planning goal 15, the Willamette River Greenway, various chapters of the county's comprehensive plan, and some specific sections of our zoning and development ordinance. I am not going to go through all of the criteria listed in the staff report. I'm going to hit the highlights of the important ones that relate to what's proposed here. I'm happy to answer questions about anything else that's in the staff report or any other questions you have when I am done talking. So first and foremost, we need to look at the statewide planning goals. And in this case, of course, the most important one is statewide planning goal 15, which is the Willamette River Greenway. The stated purpose of the Willamette River Greenway is to protect, conserve, enhance, and maintain the natural, scenic, historic, agricultural, economic, and recreational qualities of lands along the Willamette River as the Willamette River Greenway. And I pasted all of that in there because I think it's important to keep in mind, and I forget sometimes when I'm thinking about protecting the Willamette River, it's not just about the the natural areas or the scenic areas. There's a recognition that there's commercial activity that happens on the river. There's recreational activity that happens on the river. And so the Greenway is intended to balance all of those needs and uses. And like I said, based on the history and the rules, what I could read and find about the Willamette River Greenway, originally it was largely established to preserve areas for public use. But importantly, the Greenway rules also recognize that private uses, including homes and docks, existed and should be allowed to continue and allow for what they call limited intensification and or changes of use. Again, there's nothing I find in the Greenway rules that requires a county or another jurisdiction to specifically prohibit development in certain areas, like we have done in the limited use areas. But I believe that was just done as by choice, as a way of implementing some of these, just a way of implementing the Willamette River Greenway to meet the rules at the time. So under goal 15, the county did adopt the Willamette River Greenway design plan with the various land and water use categories. Looking back through the history of what the county has done to implement goal 15 with the Willamette River Greenway, it's pretty apparent that very little has changed since the comprehensive plan in 1980, where I first found this map, including the policies related to the Willamette River Greenway. I can tell you that there have been 4 amendments that we know of that are similar to this one, where a specific property went through a comprehensive plan amendment to change the designation from limited use to multiple use, specifically for a dock. I read through a lot of those decisions as well, and there's not a whole lot of direction either from statewide planning goal 15 or our own comprehensive plan for what to do in some of these areas. And so because of all of this information, and because it's pretty clear that statewide planning goal does allow for limited intensification of existing uses, at this case, which would be allowing an accessory use, a dock, to an existing single family dwelling, staff doesn't find anything inconsistent, doesn't find that this proposal is in any way inconsistent with statewide planning goal 15. And so it can be found that this proposed change remains consistent with goal 15, and that the county's plan would still remain consistent with goal 15, even with this one change to the map in the comprehensive plan. Other statewide planning goals were looked at and discussed in the staff report, including goal 3, agriculture. This is technically zoned agricultural land. AFU is agricultural land. I think it's pretty clear that this is not high value commercial agricultural land. It's half an acre that already has a house on it. It actually has class 6 low value soils. And there's no reason to believe that allowing an accessory use to the single family dwelling that exists on this lot would impact surrounding agricultural uses in any way. And then of course I have to bring up goal 12, transportation. As many of you may know, anytime you want to make a change in your comprehensive plan or your zoning code, goal 12 says that you must comply with the transportation planning rule. In this case, it's pretty easy. The transportation planning rule it really addresses additional trips that you would be creating by changing uses. In this case, it's not really changing the use. It's simply adding an accessory use to an existing single family use. And so no new trips would be expected to be generated. And so no traffic study was required for this. And it can be found consistent with the transportation planning rule for that reason. So then going on to our comprehensive plan policies, I was really hopeful that our comprehensive plan would give me a little bit more direction when it came to the establishment of the limited use and the multiple use areas in our in the Greenway design plan, but it does not, and it identifies the limited and multiple use designations. And I think I said this, but I think it's important to understand that the limited use and multiple use designations really apply to the water portions of the river, the ones that are identified on the map. It's not a designation that's given to the land. It's not any specific zoning overlay. It's just something that's identified in the design plan. And the comprehensive plan really doesn't have any specific policies that direct the designation of these areas. And there's not even any really direct correlation between the adjacent land use designation or zoning, or even uses and the limited and multiple use areas. The only thing that gets us kind of close is this policy here, 3.C.6.5, which specifically says we have to prohibit private non-commercial docks and moorages and limited use portions of the Greenway to protect the natural river character. This idea that something is different about these limited use rural portions to protect the natural river character is sort of the only correlation that we can make, and to identify why certain areas may have been identified as limited use. And I think it's pretty clear, if you recall the aerial photos that I showed earlier, that the area immediately surrounding the subject property is already developed. The river is not currently maintained in its natural state. There's houses, there's docks. When you build houses and docks in these areas, or when you do any type of development, there are requirements to preserve as much natural vegetation as possible. But this isn't an area of the river that is really maintained at all in a natural state. And I think it can be found that this area around the subject property really is the multiple use category is really even more appropriate than the limited use category. There are some other policies related to the Willamette River Greenway. They talk about things like supporting regulation of recreational activities, talk about implementing the Willamette River Design Plan, and talk about maintaining rivers and streams in their natural state to the maximum practicable extent. And again, but there's nothing that really tells us why this limited use is appropriate for this area that already has development. And there's really nothing that specifically prohibits any type of development along the river. It just needs to be done in a responsible manner. Other chapters in the comprehensive plan were looked at, and there are a few other policies that were identified in your staff report. I mean, these other chapters deal largely with coordination and procedural requirements, including the notices that were sent out, providing opportunities for public comment, having public hearings to provide for opportunities for the public to weigh in on the applications, and all of the applicable rules were followed, and along those lines, section 1307 in our zoning code outlines those procedures for us, and all of those were followed. And then the other chapters again deal with this agricultural lands that I talked about a little bit, related to goal 3 and the transportation system, which again, this isn't expected to generate any new trips. It's simply an accessory use to a single family dwelling. So staff found that the proposal to change the designation from limited use to multiple use on map 3-1E of the comprehensive plan meets all of the applicable criteria. And so we are going to go on and talk about the dock itself. So the second piece of this is the actual application under the Willamette River Greenway dock application for approval to construct the dock itself. And so you may say to yourselves, again, some of you have been here for a while, why I've never seen a dock approval. You know, Martha's never brought us a dock approval. Why are we seeing it now? Well, that's because typically this is a type 2 land use permit, which is ministerial. It is approved by the planning director or staff, and it does not generally go to public hearing. In this case, however, it was filed concurrent with this proposed comprehensive plan amendment, and that is a type 3 application. Section 307 of our zoning code specifies that if you're submitting concurrent applications and one of them is a type 3, they both have to be consolidated and processed as the type 3. That's why you are seeing this application here. I think it's important to reiterate as we talk about the dock and the standards that a dock would need to meet is the dock cannot be approved if the comprehensive plan amendment is not approved. It's very clear that this subject site is currently in a limited use area and docks are prohibited. But I am going to talk about the standards that a dock needs to meet if the comprehensive plan amendment is approved and this area is in front of the subject property is changed to a multiple use area. So it's just something to keep in mind. These are the drawings that the applicant provided. This is the proposed dock. It's pretty straightforward, typical looking dock for this area. It measures 20 by 35, 700 square feet. Has a couple of pilings that will connect to the ramp down to the dock. Docks are regulated, docks on the Willamette River regulated through a zoning and development ordinance, section 705, which is also called the Willamette River Greenway. There are a number of criteria listed in there that docks need to meet. First and foremost, 705.04A stipulates that docks need to be consistent with the purpose of this section. In the purpose of this section, it specifically talks about the limited and the limited use area and the prohibition of docks, and a few other items, including maintaining as much vegetation as possible, and basically, this proposed dock would be consistent with those purposes if the comprehensive plan designation is changed to the multiple use from the limited use. This section in 705.04C and D talks about or goes on to require that the buffer around the river be preserved and landscape areas, open space or vegetation be provided to the maximum extent possible. And again, it's this idea that doesn't mean you can't develop anything, but you need to disturb the area as little as reasonably possible. Docks are constructed along the Willamette River all the time and able to meet this criteria. Docks themselves are a water dependent use. They do require pretty minimal disturbance to vegetation just for the piles of gangway and the ramp. My understanding is that this proposal would not even require degrading on the bank. And so it can be found to meet those criteria related to preserving the buffer and vegetation. And then in subsection G 1 through 3, the zoning code identifies specific standards for the dock, and where this dock is located, the maximum size is 700 square feet. It's exactly what is being proposed. The maximum length to width ratio is 3:1. The measurements of 20 by 35 clearly meet that. Only one dock is allowed, which is what's proposed. And then there's some standards for specific colors that will be used, which the applicant has indicated they would comply with. And it also is included in the conditions of approval. And then finally, there's some language about registering with the Oregon Division of State Lands, which is essentially what the comment that you received today is getting at, that comments directly from DSL. And there also is a condition to ensure compliance with this. And so it can be found that proposed dock meets all the applicable standards, again, assuming it is not in a limited use area. And so finally, staff does find that the proposal meets all applicable criteria for the comprehensive plan amendment to map 3-1E for the multiple use designation. It meets all the applicable criteria for the Willamette River Greenway private non-commercial dock, assuming that comp plan amendment is approved, and subject to the specific conditions that are listed on pages 2 through 4 of the staff report. And so staff recommends approval of both of these files, subject to those conditions of approval. That is it for me. I went through a lot. I talk fast like usual. So anyone who has any questions, I'm happy to answer.
Martha, I have a question right off the bat.
Sure.
Is this going to provide a pathway to continue adding docks in the limited area?
So
Yes.
yes and no. This has been done 4 times before in the limited use areas. This would be the 5th one, since and the other few were in the mid 1990s. It requires a comprehensive plan amendment, which a lot of people are not willing to do. It is not an insignificant undertaking, but it doesn't mean, but certainly other properties could come in and try to do the same thing. Yes. And honestly, the fact of the matter is there's not a lot of strict criteria that tell us we have to prohibit this. And so it would be difficult for a property like this, it would be difficult to argue that it's not similar to these other ones that have been changed from a limited use to multiple use. With that said, this is property specific. This is only this property. If any other property owner wanted to come in and request this, they would have to file their own separate application for the comprehensive plan amendment.
The reason I ask, as I dig through the comprehensive plan, I came across this, this quote, comp plans are not, however, engraved in stone. They eventually have to change in community needs, goals, and resources. Changes, in fact, state rules encourage the periodic review and update of local comp plans. And that's why I was asking, is that instead of having a checkerboard of areas that have now unlimited use in a limited area, how would you enforce that? I mean, it would be very difficult to enforce your limited areas if there was checkerboard effects of amendments to the comp plan not done through a pathway, so to speak. What I see is something that could be better off done if it was done in a reach, so to speak, a river's reach from River Mile Point to another River Mile Point. I don't know. I'm just throwing that out there. This is something that was stirring with me today.
And that's a fair point. I guess what I would say is we do have 4 of these that have started to create the checkerboard. There may be other ways to handle this. Jennifer and I have actually been talking about it. It's completely unrelated to this application. There may be a different way to handle this issue of small lots on the river with existing dwellings, and limit it to potentially allowing docks in a few additional areas within the limited use zone rather than changing it. But you're right, this does create a bit of a checkerboard, and there certainly may be better ways to do this.
Okay, I'll let someone else speak. Louise.
Yeah, thank you. Am I reading correctly in the staff report? This dock is already built, because it talks about aerial photographs comparing 2019 and 2022, and says that it appears that the dock has actually been installed in violation of the Willamette River Greenway plan. Am I reading that correctly?
You are reading that correctly, and I brought that up in the staff report because both in the application and the aerial photo that I pulled, it was obvious that there was a dock in front of this property. The applicant actually called me this afternoon, and I believe the applicant's son may be here to testify today. I was told that that's actually the neighbor's dock that had been over there for repairs. I don't know what the right answer is. Whether or not the dock exists in violation or not, it doesn't affect whether or not the proposal meets the criteria for the comprehensive plan amendment. I knew someone was going to ask me about it if they saw the photo in the application materials, and I just sort of wanted to bring that out there.
I just wanted to, if this was this applicant's dock, to me, it would open a Pandora's box where individuals could just put up a dock and then later ask for, a comp plan amendment to be legalized, if you will. Because this says, if the dock is there illegally and we approve it, then it gets to stay. Otherwise, it has to be removed. I just didn't, I was just concerned, just like Murph was concerned about a checkerboard. I'm concerned about people just going ahead and putting the cart before the horse. Oh, let's just put up a dock, and then, they may see it. Let's file for our, plan amendment. That's the issue in general that I just wanted to get out there and have people thinking about for the future.
That's fair.
Okay, thank you.
Michael,
Please go over what's the difference between a limited and a multiple use. What are the specific differences there?
As far as we can tell in our comprehensive plan, the only sort of practical difference is that new docks are allowed in the multiple use area and they are not allowed in the limited use area.
Okay, and so those 9 properties there along the river, some of them have docks already, and so they already have multiple use, right?
Well, no, they're still in the limited use area, but the docks that existed there were there prior to the establishment of the greenway and this limited use area. So they're older and they're allowed to continue to exist. They're essentially a non-conforming use.
Okay, so going back to what Murph was saying, this checkerboard effect, why can't we just amend it so that all of those properties along there get multiple use? Do they have to individually come in and waste our time because they're already there?
So the properties that already have the dock are allowed to keep them and replace them as long as they meet our size and other standards for docks. It would be the properties that have a house now but do not have a dock yet, like the subject property, that would have to, the owners would have to come in and request a change to the multiple use.
And those properties on the other side of the river where you noted there, are they the same situation? Do they all have multiple uses on the other side of the river?
Those are all in what you saw in the aerial photo. The houses that have docks, they're all also in a limited use area. Those docks were, I didn't look up every single one of those in our dock files. Unless they're violations, those also all were pre-existing and are allowed to continue and could be replaced.
Okay. Seems to me like last time we met, we had an issue about code enforcement. We're continuing with that. If this dock was put in there and there was no code enforcement on it, and now they're coming back, going with what Louise was saying, that, we're missing the boat here if we don't have code enforcement. Thank you.
Well, and That's fair, and I would argue that the first thing that code enforcement would have them do is come in and apply for whatever land use application they needed to authorize whatever use it was. And if they couldn't get approved, then it would have to be removed. Nothing that we're doing today would change anything about our code enforcement process and about the fact that somebody could put something anywhere in violation and then come in and apply to remedy that.
Anyone else?
Yeah, I've got a couple questions, Murph, if that's all right. This is Tom.
Go
Tom
ahead,
too.
Tom, too. Yeah.
Martha, thank you for an excellent and very succinct report. I appreciate it. So this little subdivision that's there, or this existing set of homes, there's 10 homes, or excuse me, 10 lots, 9 homes, 5 docks that all existed prior to the establishment of the Greenway. Is that correct?
Yes.
So this will be the first new dock in the Greenway
In this small.
that wasn't grandfathered in, so to speak.
This would be the first one on that road. There were 4 other instances in the mid 90s where the limited use designation was changed to multiple use to allow for docks.
Okay.
In other limited use areas. I don't believe it was any of these houses along here. In fact, I know that it wasn't any of those.
And so that all the other lots would remain non-conforming uses, but still designated limited use.
Yes.
Okay, very good. And then the other question I had is, are there any other regulatory agencies other than the Department of State and Lands that have any kind of jurisdictional interest in a decision we might make here? Because it sounds like the jurisdictional decision or muscle about whether the dock's conforming and whether the dock specifically is correct in its usage is the DSL. Is that correct? Not us.
It is us. We have our own standards, and then DSL has their permitting requirements and standards. And so in order to approve a dock, you need both. You need a permit from both agencies or jurisdiction agency. There are possibly other state agencies that would have interest in this, including DLCD, the Department of Land Conservation and Development, because this relates to the statewide planning goals, and specifically Goal 15. But there's no additional permitting that they would require. They're given notice and an opportunity to comment about whether or not they think the proposal meets the applicable standards.
But given the fact that there's a dock, we don't know whether it's the neighbors or the applicants, has the DSL, would the DSL inspect that? Is there some, and again, I apologize for my ignorance here, but it seems like if a dock exists there, the DSL is the one that will be concerned with its dimensions and color and those other issues, despite our use. Is that correct?
I don't know what their specific standards are, to be honest. I just know that, and Jennifer may have more knowledge about this or not, I'm not sure. I don't know the specific standards that DSL has to obtain their permit. I do know that we have standards related to size and color. I couldn't imagine that DSL would have standards that would be different than ours if they had standards related to size and color. But there, I'm sure, are other criteria that need to be met.
But then it does become important to kind of give conditional approval. Would you? I mean, I know there's other conditions in your recommendations, and I read this, but as far as DSL, would your recommendation be specifically that we approve subject to DSL's approval, or is that just their end of it, so to speak?
So there is a proposed condition in there that requires that any necessary permitting from DSL be obtained. And so we do condition it on that. And correct me if I'm wrong, Jennifer, I mean,
The language is going to get interesting here.
Generally, the way this works is that they get this land use approval from the county. They get their approval from DSL. They still have to come in and get a building permit for the portions of the dock that are on land, right? And so, in reviewing that building permit, we will look and make sure that they have their appropriate land use approvals and DSL permits.
Okay, so there's another step there to verify that the dock is appropriate based on all the jurisdictional requirements.
Yes,
I mean,
although I
yeah,
saw Jennifer on mute.
Yeah, I mean, I'm not going to pretend to be an expert on DSL system. What I'm aware of, my understanding, and they may call it a registration, but in a way it's like a lease. I mean, the water doesn't belong, the water is waters of the state. And so there is a permitting process where DSL is essentially giving people permission to have a dock on waters of the state. And there are standards for that. I believe they have to be renewed like every 5 years was the last I heard. I don't know if that's changed, that it comes up for renewal. We don't do that, but that's through the state. I believe they do have some requirements now that relate to docks being fish friendly. So there are some standards that relate to that we don't apply, but that I believe DSL applies. And so regardless of anything you do, they're subject to state law no matter what we say. And our just, kind of works the other way around, right? That they've got more authority than we do, really. But they'll have to comply with their standards and our standards in order to keep the dock there lawfully.
Thank you.
I have another question. It might not be germane to what we're talking about here, but those other docks that were grandfathered in, if they sell the property, will the new owner have to get a permit for that dock? And also, if we have an issue with a flood or something and the dock gets destroyed and they want to put a new one in, will they have to go through this process of getting a land use, multiple land use for a new dock?
So I'm going to answer the second part first. Because we would look at these docks as a non-conforming use, they could replace it, and they could go through an alteration of a non-conforming use if they were going to replace it. If it was destroyed, they would not have to go through a comprehensive plan amendment to change the designation to multiple use. I already forgot the first part of the question. Oh, do they need a permit? I don't know what DSL would require of them, but I know that the county would require any sorts of necessary building permits, and as part of that, we would require an alteration of the non-conforming use if they're changing it.
The first part was if they sell the property, Marcia.
Oh, I'm sorry. Yes, it goes with the property, and we would not require a change of ownership doesn't trigger anything in terms of a land use permit. I don't know what it triggers in terms of the DSL permitting or registration. Maybe I'm not using the right words.
I'm going to make an assumption here that Army Corps of Engineers might have a say-so on this also, since that's a navigable river. So also there's a couple endangered species in there that are salmonoid. So that's another issue. And that's another issue for the limited area, is for habitat. That's something I could find when I was digging through this. I came across Oregon Department of Fish and Wildlife Residential Dock Guidelines, February 2016. It's a 6-page paper, and it goes on to describe the size of a dock, which should be no larger than 144 square feet. It should have perforations in it, so light can pass through it, and it's not a place for predators to hang out. This is based on findings from National Marine Fisheries and Oregon State Lands and Oregon Department of Fish and Wildlife. It goes on, it's a pretty interesting paper. I'll pass through, and I'm kind of surprised that Clackamas County isn't leaning on this, since our comprehensive plan says that it would coincide with some of our wildlife and natural issues that to preserve our natural wildlife. So this is something that I kind of funny that I didn't see it anywhere within the comprehensive plan being mentioned. Of course, this is 2016, and how old since the last time this greenway had been updated? So there is a challenge there, I think, for planning. Okay, I'll move on. Louise.
Yeah, thank you. I don't know if this is totally relevant, but I was curious if the Department of State Lands, the DSL, got involved with the docks that were grandfathered in. Because see, I don't know what happened first. Did the Willamette Greenway designations happen first, and then DSL got involved, or has DSL always been involved with a dock on the state waterway? So, in other words, do those people who are grandfathered in and we don't have to worry about their docks, do they still have to go through the DSL permitting process?
Yes. They do. I don't know what came first, but even the non-conforming docks have to register. And it is every 5 years. And it can be transferred to a new owner if your registration is current. And they appear to allow much, much larger docks than we do. So we're more restrictive. I just found it on their website quickly. Got a quick little tutorial because you guys were all asking such good questions.
Thank you.
Tom, one, you had a question?
Jennifer just answered it.
Oh, okay.
You're on mute, Mur. Mur, you're on mute.
Thank you. It's supposed to know when to take that off. Okay. Have we received any correspondence on this matter other than those items in the meeting packets?
Just the one exhibit from DSL that was emailed to you all earlier today.
Are there any government agencies here to provide technical information to this application? And it doesn't appear. Just the wetlands from DSL. Are there any other questions from the commission? Okay, the applicant may now present proposal. You have a maximum of 60 minutes.
Darcy, that would be Joshua Griffin. Okay. Thanks.
Hi there.
Hi, Mr. Griffin.
How's it going?
Good.
So I am Everett Griffin's son, and I just want to clarify about the so there was 2 photos presented in the packet on page 5, I believe.
Mm-hmm.
And you guys talked about it earlier about how you could see a dock in, so there isn't one in the 2019 aerial photo. And that is the correct photo. The 2022 one, for some reason, the neighbor to the left of him, he replaced his dock and just moved the one that he had replaced. And that's probably why it's showing in the 2022 photo. And that dock is now to the right of him. So there currently is nothing in front of his property. So I just want to clarify that.
Okay. Thank you. Anything else?
And if you guys need a picture of that, I can provide that as well. Like I can go to his property and take a picture of the waterfront in front of his his yard and show that if you need it.
Martha, would you need any pictures other than what you already have?
No, I don't think that's necessary. But thank you for clarifying that.
Yep, no problem.
Mr. Griffin, what's your relationship with the applicant, Everett?
I'm the son
Okay.
of Everett, yeah. Yeah, he had to work, so I just popped on here for him just to listen and answer any questions. Have you guys had any?
How long has he owned the property?
He's owned it since, I believe, 2017. I would have to check that. It's either 2016 or 2017.
Is he a fisherman?
Yes, he is actually.
Thank you.
Mm-hmm.
Murph,
You're on mute, Murph.
you're on mute again.
I'm sorry, that darn thing. Thank you, Mr. Griffin.
Yep, no
Okay.
problem.
We're going to move on here. Are there any representatives from community planning organizations or hamlets here to speak? I don't see any unless Sarah.
Nope, doesn't look like it.
Okay. Does anyone wish to speak in favor of this application? Each person will have 3 minutes to testify. Please use the raise hand feature if you are in the audience and wish to testify. For the record, please begin by stating your name and where you are from and who you are representing. If you would like a copy of the final Board of County Commissioners decision on the matter, please provide your mailing address. Does not. Does anyone wish to speak in opposition of this application? Each person will have 3 minutes to testify. Does anyone wish to provide neutral testimony? Okay. Does the applicant wish to provide, or no, there's no rebuttal. Okay. Does any person wish to request an opportunity to present additional evidence or arguments, testimony regarding this application? I probably don't think so. The applicant is allowed at least 7 days after the record to close to all other parties, submit final written arguments to support of the application. Alternatively, the applicant may waive that 7-day period. Does the applicant choose to waive the additional 7 days? Josh?
That I don't know. I would have to check with my dad on that. So yeah, he would have to get back to you on that one.
Okay, thank you.
I don't think there's any reason, Murph. There was no opposition, and so there's really nothing to address. And if he were to need additional time, we can do that at the board level. So I don't think you're in danger of any kind of procedural error by just having the commission make a recommendation tonight.
Thank you,
Okay.
Jen. Okay, the public hearing is now closed. Are there any further questions from staff from the Planning Commission? Is there any discussion by the Planning Commission?
If there is none, I'm happy to make a motion.
Commissioner Stevens?
I'd like to make the following motion that the Planning Commission recommend to the Board of County Commissioners approval of Z0315-23-CP and Z0316-23-R.
I second.
All in favor?
Aye.
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 All opposed? Okay, motion passes. Thank you.
Jennifer, can I ask a clarifying question? Is the assumption that would include the recommended conditions of approval? the way that the motion was worded?
Sure, but if Tammy wants to offer a follow-up motion, that'd be fine also.
I should have added as written. I apologize, but that was the intent.
Okay. I'm fine with that. I just wanted to make sure that there
Okay.
wasn't,
I
Would there be
read the
any other
conditions. They looked perfect. So as always, Martha.
thank you. I forgot I was not muted.
Okay, motion has been clarified. Thank you. Okay, this public hearing is now closed.
Pete had a question.
Tom has his hand
Oh.
up.
Who has a question? Oh, Tom, I'm sorry.
Hi, it's more of a comment. In listening to the conversation, I think Michael raised a good point about this kind of piecemeal approach to these. And I think we have probably similar situations throughout the county for various other properties that were grandfathered, but as soon as they try to change something, now it's a problem. And it just seems like this may be a potential work item for your work plan to kind of go through, kind of like we did a few years ago when we went and updated all the ZDOs and, update the language and try to clarify. It seems like that might be something to consider for the future, to kind of go back and look at where do we have all these kind of unique situations where, one owner is fine, but the guy next door isn't. But if he changes it, he wants, and it just seems like if we're going to approve these anyway on a one by one basis, it seems like it'd make more sense to look at it more holistically and kind of say, hey, here's some problem areas we have around based on what we've known or based on cases like tonight we had, where we should go back and kind of clean up the zoning a little bit and say, I think it's time for us to be consistent, like tonight would have been, is a good example. So it's just food for thought. I know you have a lot on your plate right now, but if you're looking for ideas for more work, that's a good one. So.
No, I am laughing, of course, because I'm never looking for more work, but we always have more work than we have people. But Martha and I have discussed it, that generally speaking, our greenway regulations need some updating. So it isn't going to happen this fiscal year, most likely,
No,
but it is on a list, and so there's other things that need fixing besides this issue, but
I understand, but I guess
this is definitely, there's other greenway things that need fixing besides this, but it would be good to try to find, because I agree with you, this piecemeal thing is not efficient.
Yeah, I guess what I would ask maybe is, normally during the budget cycle, we often get a chance to see what you have been asked to do or you're proposing to do.
Right.
Give us an opportunity to comment on it. And I remember from years past that, things would keep on the list. That's okay. You want to keep them on there so eventually they get done. So maybe all my request is put it on the list. Maybe someday we'll get to it. That's all my request is.
Okay. That makes sense. Yeah. Thanks, Tom.
And Jennifer, I had a question too, very related to Tom's question, but would this be, what I was thinking earlier, is this legislative to make if we made serious changes to the limited versus unlimited areas, that would probably have to go in front of the voters, wouldn't it? Nope.
No.
It could
No.
just.
Zoning regulations, land use regulations don't have to go to a vote. So no, but it would be most likely treated as a legislative amendment. It depends. Sometimes the line between what's a quasi judicial application and what's a legislative amendment is not a bright one. So it would depend on what it exactly looked like, but we could do it at the county level.
I see.
Wouldn't need to go to the voters. The board could do it.
Right. Thank you. Michael,
Yeah, Jennifer, I have a suggestion on this. I agree with Tom. We need to take a look at some of these things. And I don't want to put more work on you. But if the county has an opportunity to have college interns come in, this would be a good research project for them to take a look at where we have these similar type properties that need to be looked at. And that wouldn't be, your staff could continue doing what they do, and all they'd have to do is go back and take a look at the recommendations or the findings of the interns to say, okay, here's where we need to look at, like these 9 properties along the river there, or maybe there's some more properties upstream or downstream that would fit into this category. That's just a suggestion.
Yeah, no, that's a good idea.
I mean, as an old title insurance person, zoning is generally not something the title insurance companies consider, but they have, the joint plant in the Portland area has a wonderful set of records to identify these kind of things, potentially, depending on taxes. And I'm not suggesting a third party is the answer to any of the problems here, but necessarily it is a opportunity perhaps to get the work done by someone else. And
Anything like
I'd be willing to make a phone call on that if it ever comes to fruition. So,
okay, great ideas, everybody.
awesome.
That would also provide you an opportunity to find some candidates for employment.
That'd be good.
Assuming there are candidates to be found.
We have minutes to update or approve, not to update, but to approve.
I'll make a motion to approve the minutes as written.
Do I
A
have a
second.
I'll second that.
Michael beat you to it.
all in favor?
Michael's on it tonight.
Aye.
hi.
Aye.
Aye.
Aye. Okay.
That was unanimous, Darcy.
Well done, Darcy. Thank you.
Schedule.
Schedule, which I of course don't have in front of me. We had held the first meeting in November on the chance that this needed to be continued. Obviously it did not. So your first meeting in November is canceled. And the second meeting in November, which is the Monday after Thanksgiving weekend, I believe, Martha will be back again because we're just keeping her extremely busy with a comp plan amendment, zone change. Remind me, Martha, this is to rural industrial?
No, it's
urban industrial, light
it's in the
industrial.
urban area. It's to light industrial.
Yeah.
From
So it's
medium density residential.
Okay. So it's something, it may look familiar to some of you because it's in an area that the zoning is a little odd, and we've had a similar request once or twice before. So kind of similar to this dock thing, that maybe there was an area that shouldn't have been zoned the way it was way back in the day. So we will be, Martha in particular will be, actually, I think I'm maybe not here that day actually. So, oh no, I am, the 27th, I am. So I'll be here and Martha will be here doing all the hard work as usual. And then I don't really know at this point. The second meeting in December is already canceled because it's like Christmas
On Christmas
or something.
We
But
don't get to meet on December 25th.
We're not
It is
gonna
Christmas
be-
Day.
Darn.
Christmas
I know.
Day. Yeah.
something about it being a legal holiday kind of puts that out of the possibility. But the
Yeah,
first
as much
meeting
as we love to hang out with you guys.
Yeah. Exactly. Exactly. The first meeting in December, I don't know yet. There's an outside chance that we might want to come talk to you about some code amendments, but so I don't want to cancel it yet. We'll call it tentative right now. So that's it for now. That's all I got on the schedule.
When do you have a new work plan coming out?
So we didn't do a full like work plan the same way we have in some past cycles this time. It was a lot less formal because the reality is we just don't have the resources to allocate to a whole lot beyond what we actually kind of have to do. So we can send you the work plan. I'll make a note to do that. But it's pretty well going to be limited to what we are required to do this year. So there's some, well, it's a little more than that. I take it back. We're doing a minor amendments package that we try to do every year. And this time the focus is on state legislation and things that the legislature did mostly in 2023, but we still have some stuff from a couple prior sessions that we haven't completely incorporated in our code. A lot of it is housing focused, where they've passed some things that we're either required to do or some optional things that the county can consider doing related to housing. So we'll be doing that. And then we did do a study session at some point with you on the climate friendly and equitable communities rules, which has some parking requirements. And the board had tabled that for a bit for a couple of reasons. And so we did get an extension. So we've got to now comply by the end of June. So right now we have a policy session. If any of you are bored, you can listen on Wednesday. We'll Martha again, because Martha does everything. We'll be doing a policy session with Karen on Wednesday to talk about the climate friendly and equitable communities rules. And what was 2 weeks ago, Martha and I were at the board talking about some of this housing stuff. So there will be a package coming, but I wouldn't anticipate we would be to you until early next year to talk about what exactly the parameters of that are. And there are some policy decisions to be made, because a couple of things that the board did, or excuse me, that the legislature did are optional for counties related to rural housing. Rural accessory dwelling units is one, and the other one is RVs, the ability to have an RV on your property as a second dwelling. You can't have both, you can't double dip, but you could have either the ADU or the RV. Rules aren't exactly the same about which properties will qualify, but there would be a lot of overlap for that. And it's not everywhere. It's not EFU, it's not TBR, it's not in rural reserves or urban reserves. Is that right, Martha?
Urban reserves.
Not in urban reserves. So there are limits. And so already there's a table. There'll be a table because there's going to be too many choices.
There's maps too.
There's maps, yeah.
Martha, table and map.
I know.
Exciting. So yeah, there'll be a couple of issues. I think these are some policy things that you guys are really going to be able to, I think, dig into and have some good input for the board. But so far, the board has said, move forward, let's consider it, let's take testimony, let's find out what people want to do. But we would be starting with a work session to talk it all through before we would schedule a hearing. So that's really the only thing on the land use front that's for sure going to happen this fiscal year. We're moving forward with a grant through Metro to try to do some more prep for doing more work on our code, because we never really did completely finish the ZDO update. We did a lot of work, like Tom was mentioning, we did a lot of work, but we didn't ever really get done. And we have some things that we need to do, particularly related to some of our standards that need to be clear and objective that aren't. So we're going to be trying to move forward with that, but it wouldn't be coming to you quite yet. We're just trying, have to get a consultant on board and all of that. So that's kind of the other piece that's happening right now. And then I guess the third thing, which isn't on our work program, but there may be a need to do some amendments related to public utilities and some sort of, I would describe it as unintended consequences of our code that have kind of just become apparent to us. So there's a chance that we might be moving forward with some utility related amendments on a semi-fast track, which is one of the reasons I want to hold that date in December, just in case we end up wanting to come talk to you about that sooner rather than later. So.
Louise, you have something to say?
Yeah, I do. I'll make sure I'm off mute.
How's your staffing level?
Oh, am I talking or not? Oh,
yeah, Louise, I think you are.
Jennifer.
Hang on 1 minute, Michael. Louise is going to ask something and then I'll answer that. Go ahead, Louise.
Okay, this is something that might be on the list or for the future. Carbon credits on TBR zoning. Is that something that the Planning Commission knows about, is looking into? I've looked into it a lot, And from my understanding, if you sign a contract for carbon credits on timberland, those contracts can be anywhere from 5 to 165 years. And of course, they don't allow harvest. And so because timberland, is for the growth of usually with a harvest before 165 years, I just wonder, is that anything that the county planning, does it matter, in other words? Do we need to deal with it?
Not that I'm aware of. I mean, there isn't anything, the land use rules allow people to harvest their trees on timberland, but they don't require it. So you could continue to just grow your trees for really as long as you would want to. And it's not going to be a zoning issue. So no, I don't think that there's anything that we would need to do in that regard.
Yeah, I was just a little shocked about the 165-year commitment. I'm like, I'm not going to live that long. But
a long time. That's a long
maybe,
time.
But probably not. And so I just wondered, I thought, well, that limits the use of the property for, growth and harvest. So I just wondered if there was anything out there that the county needed to consider, but it sounds like it's all okay.
I don't think so. From a zoning standpoint, it should be okay.
Okay, thank you.
Okay. And Michael, you asked about staffing levels. We have one vacancy. Well, we have one vacancy that we are planning to fill in the near term. Besides that, we have 2 vacancies that are held for budget concerns. So, it's not ideal, but it is kind of is what it is. So yeah, we're just got one right now that we're either going to be recruiting for or maybe filling from the past recruitment, depending. We're not sure. We're trying to evaluate that right now.
I'd like to make a comment about here in the corridor. There's a committee that formed that holds meetings prior to the agencies getting together on wildfire reduction in the Mount Hood corridor. And I'm on the residential end of it, which are CPOs and HOAs. And we're trying to bring communities together to reduce our fuels, come up with ideas to how do we respond? How do we make this a safer place to live? I came across something that was mentioned in our last meeting, that a tool that they were using up in the Bull Run, and it's called an air curtain burner. It was the first time I ever heard of it. Get a chance, take a look at it. There's an outfit that's titled just that, air curtain burner, and it's an awesome unit that it's self-contained. It burns slash logs, whatever, 10 times faster than burn piles, and it burns it clean, and it can move from site to site. Just gives community another tool for communities to work with. I thought I'd throw that out there because it's something pretty interesting. It's something to look forward to. Brainstorm.
Interesting.
Yeah. Anyway, anyone have anything else?
Have a good Halloween.
Yeah. Yeah.
Where are you going as, Tammy?
Superwoman. I have the outfit. I'm doing it. Yeah.
Don't they call that
Halloween.
typecasting?
Pardon?
Isn't that typecasting?
It is, but guilty.
When you actually
charged.
show as yourself?
Oh, that was pretty cute. I like that. Thank you, Dorothy. No, you can thank Rick Cook for that. Sent me the outfit, that guy. Anyway, always good to see everybody.
Good night, everybody.
Good night.
Good night.
Good night.
Thanks, Murph.
You betcha. Thank you, everyone. Take care.